complaint or your, I guess, answer, if nothing else. Mr. McLaughlin's not here. Are you still locked out?
Yes, sir.
Okay, so how long have you been locked out?
I've been locked out over a week. And
What date? Give me a date, do you know?
it was Saturday.
Saturday,
Yes.
the 20th?
Yes.
So, I mean, I see this here. The locks just got changed?
Yeah, he just changed the locks. He tried to offer me $400 to move out so that someone next door could move in. And I told him, no, I'm not doing that, And
right out of the gate, this case already feels explosive because the judge is hearing two completely different realities. On one side, you have a tenant claiming he was suddenly locked out of his home after refusing a cash offer to leave. On the other side, there's a landlord who hasn't even shown up yet to explain himself. And that matters. In housing court, appearance and timing can completely change how a judge reads the situation. What makes this even more dramatic is the emotional layer already entering the courtroom. The tenant isn't just talking about inconvenience, he's talking about medications, housing instability, fear, and alleged criminal activity inside the residence. Those details instantly raise the stakes because now, this isn't just a rent disagreement anymore. This starts sounding like a possible illegal self-help eviction case, and judges absolutely do not like landlords taking matters into their own hands outside the legal process. Also notice Judge Simpson's tone here. He's calm, but he's already gathering timelines very carefully. That usually means the court is preparing to test credibility later. And trust me, credibility is about to become the entire battlefield in this case.
he kept trying to offer me money. The next he came in and before that, two individuals that stay in the same house I stay in at 4 a.m. in the morning tried to break into my room. And I told the police about it and everything. And next I told Mr. McLaughlin, and he told me, he said, so what do you want me to do about it? And it's like, as part of the rental agreement, there's no criminal activity supposed to be taking place like that, in this house. No trying to break into anyone else's property and stuff. And
all right, sir, have you talked to legal services at all?
I've been to legal aid, yes, sir.
Okay, what did they say?
I have my case manager here from CMH with me. Is it okay?
Oh, okay, hold on. So you're a CMH consumer?
Yes.
Okay. All right.
All I know is my medication, my heart medication, my seizure medication, my lung medication. I've been without it. And this guy won't let me get it. And I've been really sick. And I've been wearing the same clothes and I feel horrible. My rent is paid for July and all that.
Pardon?
My rent is paid.
So, okay, hold on a second. So your rent, you paid your rent for July and got locked out on July 20th?
Yes.
All right. He's not here. I'm going to treat your complaint as a counter complaint for lockout.
Yes, sir.
Okay, so there can be some serious consequences for him in terms of a money judgment if he has locked you out of the premises and doesn't sort of answer this claim here, but he's not here right now.
This is the moment where the courtroom temperature suddenly changes. Judge Simpson is no longer treating this like a routine landlord-tenant misunderstanding. The second the words illegal lockout enter the discussion, the financial danger becomes very real. And notice how carefully the judge phrases everything. He's not saying the tenant automatically wins. He's saying, if the lockout happened, the consequences could be severe. That distinction is critical in court. Judges constantly leave themselves room to evaluate evidence later. But even with that caution, you can already hear concern building in his voice because courts generally expect landlords to use formal eviction procedures, not changed locks and negotiations at the door. What also stands out is how emotionally persuasive the tenant appears at this stage. He's describing being unable to access medication, clothes, and shelter while claiming rent was already paid. Those are details that naturally generate sympathy. And here's the dangerous part for the landlord. Once a judge starts thinking someone may have been illegally removed from housing, statutory penalties can escalate fast. The court is now moving from disagreement territory into possible statutory violation territory.
So I'm going to adjourn this out 1 week, give him an opportunity to show up.
Okay.
And if not, then I'll figure out exactly what I'm going to do. Typically, just so that you know, and you're telling me it's from the 20th. That was the day that the locks were changed. It's on the 20th?
Yes, sir.
Okay. So
I left out with a friend to go get something to eat because I had no food.
5,
and when I came
6,
back, he's standing there
7,
with the
8.
locks changed, and he's got a camera at the back door. I'm like, "What are you doing? Open the door." And he's like, "No. How much money you want, Daryl? I'll give you $400. I'm like, "Listen, man, I don't want anything. Give me back in my place. What are you doing?" And I was really upset, because I'm standing with groceries that I just got from, with a friend, and they wouldn't open up the door. And he's standing there just filming me, laughing,
All right. Okay. So just so that you know, under the lockout statute, it's typically $200 a day minimum that he may owe you.
Yes.
So I'm not saying that's what I'm ruling, and I'm not saying that that's what I'm doing. I'm just letting you know that because of what you filed. So I'm going to put it out to the 2nd at 12 p.m. Give him an opportunity to show. If he doesn't show, then likely what's going to happen is, well, I'll have to figure out something to do because I want you to get back into your place.
Okay, but Your Honor, at this time, I have no place to go. I've been out on the streets, and I haven't been able to change clothes or nothing, and I've just been enduring this.
This testimony is emotionally powerful because it shifts the courtroom from legal theory into visible human impact. Daniels is describing survival conditions, not just inconvenience. Same clothes, no stable shelter, no medication access. Those details are designed to show harm, and judges listen very carefully when actual damages start becoming tangible. But there's another important layer happening here. Judge Simpson is balancing sympathy with procedure. You can hear the judge basically saying, "I understand your situation, but I still have to follow legal process." That tension exists in almost every housing courtroom. People often expect judges to instantly fix emotional emergencies, but courts move through evidence, notices, hearings, and statutory requirements. At this point, Daniel still appears credible, and that's incredibly important because credibility often outweighs emotion in long hearings. The judge also seems frustrated that an immediate solution may not actually solve the tenant's real-world situation tonight. That's why he starts discussing orders to show cause in future hearings instead of simply issuing dramatic instant rulings. Question for viewers: if someone told you they were locked out while their medication was still inside, would you automatically believe them, or would you still wait to see the evidence first?
And I'm right here with my case manager, and I don't know what to do.
I hear you, Mr. Daniels. There's not a whole lot that I can do. I mean, I could give you a judgment right now, but that doesn't help your situation right now. Okay. Yeah. I'll do it this way also. Not only will we send him a notice, I'm going to issue an order to show cause on this thing.
It's my position he relinquished on the 20th. I normally would have changed them on the 20th, but my son was in town and I didn't have time. I wanted to spend time with my son.
You're saying he relinquished it on the 20th, when he receives his alleged $400 from Mr. Temple?
Yes, on my behalf. Mr. Temple fronted the money. I reimbursed Mr. Temple the next morning.
I see this, but this doesn't even make any sense to me, Mr. McLaughlin. I'll be honest with you. How much was his monthly rent?
510.
So where's the 400 come from? Where's that number come from?
Okay, he, on the 20th, he left me a voicemail saying he wanted to move out that day on the 20th, as long as he got his security deposit back. I responded that his security deposit at that time was down to $245, that I'd kick in some of my own money, making it even $400. And he accepted that.
Not to complicate things further, Your Honor, Mr. Daniels does deny,
Denies what?
he denies that that's his phone number. The text and the calls allegedly sent to that number.
Now the case starts getting messy, and this is exactly where courtroom hearings become dangerous for both sides. The landlord is trying to establish that Daniels voluntarily agreed to move out in exchange for money, but the timeline is already confusing the judge. The second a judge says, "This isn't making sense to me. Attorneys and litigants should get nervous immediately." Why? Because confusion destroys credibility. And credibility is the currency of court. McLean's explanation about deposits, rent deductions, and the mysterious $400 arrangement is sounding increasingly inconsistent under judicial questioning. Judge Simpson is laser-focused on one thing. How can a landlord deduct from a security deposit before the tenant has officially vacated the premises? That's a legal and procedural problem. The judge keeps circling back to it because he senses something irregular about the transaction structure. Also, notice how the judge refuses to let vague explanations slide. Every time McLean tries to move generally through the story, the judge narrows him back into specifics. Dates, numbers, timing, possession. That's how experienced judges test whether a story survives pressure. And honestly, the tension in this courtroom is rising because both sides are now presenting narratives that don't fully line up cleanly.
Yes, sir.
That's the phone number. I received a voicemail from him saying he wanted to move out that day, as long as he got a security deposit back. That's the previous exhibit.
Exhibit 2. Explain that to me. What you're saying there.
Basically, what this says is he started out with a $765 security deposit. He only made a partial payment on his June rent and no payments on his July rent. So by July 20th, when he said he wanted to move out, he only had $245 left on the security deposit, and I agreed to bump it up to $400.
Okay. So how is his security deposit being deducted before he's vacated? That was the question.
The $245 was arrived at by how much he didn't pay. The $765 is how much he didn't pay for his June rent and a prorated $17.
He hasn't vacated the premises. How are you deducting from his security deposit?
That number I arrived at
Not my question.
is assuming he paid.
Listen, Mr. McLaughlin, to my question. He has a security deposit. He hasn't, as of the time I'm looking at this calculation, vacated the premises. How are you deducting from his security deposit?
On a prorated daily basis. I don't understand your question, I guess.
Okay, that's because you don't understand the Security Deposit Act. How are you deducting from his security deposit? That's the tenant's money that you are holding. You do understand that.
Judge Simpson is absolutely drilling into landlord-tenant law fundamentals here. This isn't just about confusion anymore. The judge believes the landlord may fundamentally misunderstand how security deposits legally function. And that's a huge issue because housing statutes are extremely technical. A lot of landlords think they can informally calculate damages, unpaid rent, or occupancy issues however they want, but courts expect strict compliance with statute. The judge is basically saying, That money does not belong to you yet. Until lawful deductions are justified through proper process, a security deposit is still considered the tenant's money being held in trust-like fashion. What makes this exchange so dramatic is the landlord's repeated inability to directly answer the question. Every time Judge Simpson asks how deductions were calculated before surrender of possession, McClinn keeps circling without landing. That's courtroom danger. Judges become increasingly suspicious when a witness avoids answering the precise legal issue being raised. And look at the judge's body language here. Verbally, he's no longer simply gathering information. He's teaching, correcting, and testing simultaneously. That usually means the court believes statutory violations may genuinely exist somewhere inside this transaction structure.
Yeah.
So how are you deducting from his security deposit prior to his vacating the premises?
Yeah, I still don't understand the question. That would be the deduction, how much? I understand, 765 was his money. But then he.
So how are you taking it before he's vacated the premises?
I guess I can't answer the question.
Oh, no, I think you can answer it. I don't think you like your answer. Because I think you know you can't. So, Mr. McLaughlin, you've been in this court enough. If this were your agreement, which I understand Mr. Daniels is denying, why wouldn't you have just waited 5 days, come to court, stated the agreement, and then resolved it that way? If indeed this was the agreement.
That would have been an option too. In retrospect, maybe I should have done that, but he told me he wanted to move out that day on the 20th. And I wanted to honor what he wanted to do.
Okay. Is there somebody living in the premises now?
In the other rooms, yeah.
Well, let me ask this. So he's just not on the premises, right?
Right.
Everything else is the same as before he left.
Mhm.
His stuff is still in his room.
This is where the case starts collapsing into contradiction territory. Think about what the landlord is saying. The tenant supposedly moved out voluntarily, yet all of his belongings are apparently still inside the room. That immediately creates a credibility problem because voluntary surrender usually comes with actual relinquishment of possession. If someone fully leaves a property, why is all their property still sitting there? Judge Simpson clearly senses that disconnect, which is why he keeps repeating versions of, "This makes no sense to me." That phrase matters more than viewers realize. Judges don't casually say that during hearings. It means the narrative structure itself is failing under scrutiny. Then things get even more serious when signatures and written agreements enter the conversation. Once the court starts questioning whether signatures match, the hearing moves dangerously close to potential fraud implications, authenticity disputes, and evidentiary hearings with sworn testimony. Suddenly, this is no longer just a housing disagreement, it's becoming a credibility war involving documents, witnesses, and competing stories. And once courts start scheduling evidentiary hearings, everyone's exposure increases dramatically because inconsistencies become much harder to hide under oath.
And we have an agreement that he can come get it anytime he wants.
This makes no sense to me. None. I'm not a handwriting expert, but I'm also. You have a copy in front of you of your Exhibit 5? You're telling the court that's Mr. Daniels' signature?
Me?
Let me, hold on. Were you there when he signed it?
Absolutely.
Put him under oath, Mr.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help
Yes.
God. State your name.
Pat McLaughlin.
Put Mr. Daniels under oath.
Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Daryl Daniels.
I mean, when he signed this, he was standing up. So maybe that's.
Okay, and so what's that mean?
That means it might be illegible, but he did sign it.
Which copy? You have the agreement in front of you, a copy of the agreement that's signed?
Yeah, I agree they're different.
Oh, they're not just different. Those aren't by the same person.
Oh, yes, they are.
Oh, no, they're not.
I have two other witnesses who can come here and tell.
All right, then we're gonna have a hearing. You're gonna bring them in here. Everybody's gonna be put under oath, because I'm gonna tell you something, Mr. McLaughlin. This makes no sense whatsoever. That you are headed to court. You file an action, I think on July 8th. You are headed to court.
This section is extremely important because Judge Simpson is now reconstructing the timeline himself instead of relying on either party's narrative. That's what judges do when they stop trusting simplified explanations. He's laying out the sequence step by step: court filings, cash payments, unchanged belongings, altered locks, disputed agreements, and conflicting claims about surrender. And honestly, the timeline sounds chaotic. The judge is basically telling the courtroom that the entire story lacks logical consistency. That's dangerous for everyone involved because once a judge loses confidence in both narratives, the case becomes heavily evidence-driven. Witnesses, videos, texts, signatures, timestamps, all of that suddenly becomes critical. Another thing viewers should notice is how Judge Simpson keeps emphasizing procedure. He repeatedly points out that if an agreement truly existed, there were cleaner legal ways to handle it. Courts hate informal side arrangements when formal legal proceedings are already underway. Why? Because informal arrangements create confusion exactly like this. One side says voluntary surrender, the other says illegal lockout, and suddenly the court is stuck sorting through emotional testimony and incomplete documentation. At this stage, nobody in this courtroom should feel comfortable about where this case is heading.
5 days before that, somebody, or maybe even before that point in time, somebody gives $400, then gives another $400. The stuff isn't moved out of the unit and the locks are changed. Outside of that, there is then this bizarre deduction from a tenant security deposit, which apparently has occurred prior to him vacating the premises.
No,
Yes.
it's simultaneous with when he vacated.
No, but you're deducting before then.
No, but the money isn't exchanging hands until he's sick.
Okay. So here's what we're gonna do. You're gonna find me a date that we can do this. When are these other people gonna be available? These witnesses?
John Mattis is available any day. Frank Temple is available any day except Friday. Well, Friday he's available, but he works later.
Well, I'll tell you what, I'm just gonna set it and then you gotta make sure they're here. Cause I mean, I'm not gonna work around everybody's schedule. Because it's gonna be your, and I'm gonna suggest to you, Mr. McLaughlin, based on what I'm looking at, you might want to get an attorney. Because for each day he's locked out of those premises, that by statute under the lockout statute is $200 a day that you would owe him if I find that there's been an illegal lockout. Outside of that, because now he also has counsel, you could be liable for his attorney fees. Now, granted, one might say, so we can just skip over this argument, that since Mr. Henry is from legal services, that and he hasn't paid anything, you wouldn't be liable for any attorney fees. Not the way that works.
Now Judge Simpson starts talking numbers, and the financial exposure is getting brutal. This is the kind of courtroom moment that completely changes the emotional pressure on a case. Earlier, this sounded like a housing dispute. Now the judge is openly calculating potential liability in the thousands. Statutory damages, attorney fees, housing costs, continued penalties per day. Suddenly, this becomes financially terrifying if the court ultimately rules an illegal lockout occurred. What's especially interesting is how the judge preemptively shuts down a common misunderstanding about legal services attorneys. A lot of people assume that if opposing counsel works through legal aid, attorney fees somehow disappear. Judge Simpson immediately corrects that assumption. Courts can still award fee calculations comparable to private attorneys depending on statute. That clarification alone tells you the judge is taking the legal framework very seriously. Also notice how calm but direct the warning is. He's practically telling McLynn, you may want counsel immediately. Judges don't casually recommend attorneys unless they believe significant exposure may exist. Question for viewers. At this point in the hearing, who do you think looks more believable, Daniels or McLynn? Because the court is clearly still trying to figure that out itself.
He gets paid at the rate that an attorney in private practice would get paid, and that's what you would owe. If it's found that you violated that statute. So as I count it, right now, if it turns out, absent the other statutes that certainly counsel's aware of that could apply to this, just on the lockout, you're at $2,800 right at this point. And that doesn't include the
August 6th at 9 a.m.
So I'll set a hearing. That'd be enough time for you to get counsel if you want to get counsel, Mr. McLaughlin?
I didn't hear the date.
August 6th, Tuesday.
It's Tuesday? Yeah.
This upcoming Tuesday,
9 o'clock, that's fine.
August 6th,
Your Honor,
2024, 9 a.m. Yes.
if I may, would Mr. Daniels be allowed back in the premises until then? He has been being housed by community mental health, which I do have the receipts for here.
Well, yeah. Oh, that reminds me of something. Because I was informed that he was being housed by others. That is an incidental damage also, so that any housing expenses they have would also be included and are not part of that 28. But go ahead, Mr. Henry. I'm sorry, I didn't mean to interrupt.
No worries. In addition to that, I believe we have someone from community mental health here. I believe they aren't able to house him further than today.
No.
This exchange reveals something very important. Outside organizations are now financially involved because of the alleged lockout situation. Community mental health apparently stepped in to help house Daniels temporarily, and Judge Simpson immediately recognizes that those costs could potentially become recoverable damages too. That's a massive development because damages in housing cases often expand beyond rent disputes into secondary consequences caused by the alleged conduct. Temporary housing, emergency accommodations, attorney involvement. Everything starts adding up, but then notice the sudden pivot from the landlord. After hearing all the possible exposure, McLynn quickly says he'll allow Daniels back into the property, no problem. That abrupt shift is fascinating because it suggests the pressure from the court may already be influencing behavior. Yet even then, Judge Simpson still doesn't fully trust the situation. He insists on personally supervising the key exchange through the courtroom process. That tells you the judge believes trust between these parties has completely collapsed. He wants witnesses. He wants accountability. He wants no ambiguity about possession or access moving forward. And honestly, by this stage, the hearing feels less like routine landlord court and more like a credibility minefield waiting to explode.
I'll let him in. I have no problem.
When is he going to get the keys so that we're done?
Right now.
You got them with you?
I do, but I have to check which one fits the front door, so I'd have to go back. I could meet him there.
Okay. Why don't we do it this way? Because I just don't have a good feeling. Why don't you go get the key that fits, come back with the key so that I can watch it being exchanged and given to Mr. Daniels.
Sure.
So I guess technically I'll pass the matter until
Because I put in the account system yesterday, I don't have all the court filings, but I'd be able to get a copy of all that.
That's not in my home.
We can address that.
Sir,
Yes, sir.
sir, I'm not assuming, I am assuming nothing at this point. Mr. Henry, we will take care of you on that. Okay, thank you.
Thank you, Your Honor.
You're welcome. And Mr. Henry, when Mr. McLaughlin gets back, don't do any exchange until it's in here.
I'll be in front of you.
I want to see it myself because I don't want anybody, don't want to have to believe anybody else's lying eyes. Court recalls the case of McLaughlin versus Daniels. All right, on this one, you can just stay right there. Did you get it? Where's the key?
This moment may seem procedural, but it's actually incredibly revealing. Judge Simpson is personally overseeing the exchange of the key because he no longer trusts verbal assurances alone. Think about how unusual that is. The court is essentially creating a controlled environment to prevent future disputes about whether access was restored. That tells you the judge believes this situation has already become too unreliable for informal cooperation. What also stands out is how both sides are still preparing for war despite the temporary resolution. McLinn mentions witnesses, videos, and additional evidence almost immediately after the key issue is addressed. That means neither side believes the case is truly over. Everyone is preparing for credibility combat at the next hearing. And here's the deeper issue. Once a courtroom reaches this level of mistrust, every statement becomes dangerous. Every inconsistency matters. Every omission matters. The judge is now documenting behavior just as much as facts. You can practically feel the hearing shifting from "what happened" to "who can the court actually believe?" And that question is about to completely reshape this case in the second half of the hearing.
All right. Mr. Henry, can you get the key from Mr. McLaughlin? All right, that's the key to the premises.
If I may, Your Honor, my two witnesses will be here on Tuesday. I have a third witness. I was going to hopefully persuade you that
Who's the third witness?
it's a video I have on my cell phone. Can I bring in my cell phone on Tuesday?
You can bring it in. I'll take it away. All right. Thank you. We'll see everybody on Tuesday. And the gentleman from CMH, could we make sure to have what CMH has paid out in some form? Yeah. Okay. All right. Fantastic. Thank you. Daniels.
Yes, sir.
All right.
Ron, if I may before start, may I say something? Good luck.
Maybe. Go ahead. What do you want to say?
Last time I was here, Your Honor, I was scared and I lied to you.
Okay.
Everything changes right here. Up until this moment, the court was operating under the assumption that Daniels was the victim of an illegal lockout. But now, in one sentence, the foundation of the entire case starts cracking apart. And notice how sudden this confession is. Nobody forced it out of him in that exact second he volunteered it. That immediately catches a judge's attention because voluntary admissions carry enormous weight in credibility analysis. But this is also where things become emotionally complicated. Daniels isn't simply saying, "I lied." He's trying to explain fear, instability, pressure, lack of housing, medications, mental health struggles, and confusion. The problem is that courts separate emotional hardship from sworn truthfulness. You can have sympathy for someone and still conclude they lied under oath, and Judge Simpson is now entering a very different mode. Earlier, he sounded protective and concerned about a possible lockout victim. Now he's evaluating whether the court itself was manipulated through false testimony. That is a dangerous transition because judges take dishonesty personally when it interferes with judicial process. The entire energy of this courtroom is about to shift from sympathy to accountability.
I was not.
went through this with Mr. McLaughlin, and I didn't, when they wouldn't let me into my place. So I took the money.
Both sets of money?
Huh?
Both sets?
I took the money. Because I had no place to go. And I didn't know what to do. And I had medications and I was out on the street having no family and friends. And he kept pressuring me to move out so that someone else would move in. And he kept sending me emails and texts that my security deposit was going down. And I really didn't know what to do. And being not able to get back to my place where my stuff is. And I was scared. I truly was. And I didn't want to admit that I was afraid or something like that. You know, 'cause I thought it made me seem like I'm weak or something like that. And I found out that makes me seem like I'm weak by not being honest. And I apologize. Please forgive me.
So you voluntarily surrendered the apartment?
No, I didn't surrender the apartment. No, I couldn't get back in. They had already locked the doors. I couldn't get in. They're standing there. I couldn't get in.
So what are you claiming you lied about?
I accepted the $400.
Which $400?
There's only one.
Judge Simpson immediately narrows the issue down to specifics because vague apologies do not work in court. The second Daniels admits lying, the judge wants exact details. Which statement was false? Which payment? Which version of events? Courts cannot operate on emotional confessions alone. They need precise, factual clarification. And Daniels is struggling badly here. His answers are scattered, hesitant, and inconsistent. One minute he's saying he accepted the money, the next minute he's denying, surrendering possession. Then he's explaining pressure, confusion, and fear. The problem is that every additional explanation is creating more contradictions instead of resolving them. You can actually hear the judge becoming increasingly frustrated because the logic chain no longer holds together cleanly. Daniels keeps insisting the locks had already been changed before the money exchange, but the judge is focused on something deeper: if the surrender never happened. Why take the money tied to surrender discussions at all? That contradiction is becoming central, and this is exactly why credibility is everything in court. Once a judge believes a witness has lied once under oath, every later statement gets filtered through suspicion. Fair or unfair, that's reality in courtroom litigation.
Well, no. My understanding is there's two $400.
That's what they're trying to say.
Okay, so which $400 did you lie about?
A video that they have showing him giving me $400. This video.
From Mr. McLaughlin's agent.
Yeah.
You took that $400.
Yeah. They came down the bottom of the stairs and they gave it to me.
Okay.
I didn't want it, but.
Well, hold on a second. Hold on, Mr. Daniels. So you took that $400, and that was the $400 where you agreed to surrender the unit.
No, I didn't agree to surrender anything.
Then why were you getting the $400?
He told me, the gentleman said, "Daryl, listen, you might as well, have a place to stay in." And I agreed with him, the gentleman was having one. And I was like, "I'm not signing anything. That's wrong." He's like, "Yeah." He said, "I don't."
Well, so
I was frightened.
Daniels,
Yes, sir.
there's this meeting that takes place.
Yes, sir.
You're given $400.
Yes, sir.
Why did they give you the $400 if it wasn't to relinquish possession of it?
I wasn't relinquishing possession.
Okay.
I never agreed to it.
Okay. All right. Then why did you take the $400?
I didn't know what to do. I had no place to go.
What do you mean you didn't know what to
I
do?
had no place to go.
Daniels is now trying to explain survival decisions rather than legal decisions. He keeps returning to the same emotional themes: homelessness, fear, hunger, medications, mental health struggles, pressure from the landlord, nowhere to go. And emotionally, Viewers may completely understand why somebody under extreme stress could make inconsistent decisions, but legally, Judge Simpson is analyzing intent and conduct. The judge wants a clean answer to a clean question. If you didn't surrender possession, why did you accept money connected to moving out? Daniels keeps giving contextual explanations instead of direct legal explanations. That distinction matters enormously in court. Also, notice something critical happening here. Daniels repeatedly admits he thought he was being smart by taking the money while still planning to pursue action against the landlord later. That statement is devastating because it suggests strategic behavior rather than simple confusion. Judges become extremely cautious when testimony starts sounding calculated after the fact. And unfortunately for Daniels, every attempt to emotionally explain himself is colliding with the earlier sworn testimony where he denied taking the money altogether. Once perjury concerns enter a courtroom, sympathy drops very fast.
And I don't want to stay on the streets. And
Mr. Daniel,
yes, sir.
what you're saying, it doesn't make any sense.
I mean,
So, you need to start telling the truth. So,
I took it because I didn't have no place to go. I didn't have no money to get food to eat. I had medications that I had to have. And I didn't know.
Daniel, you had a place. They said, so here's what you told me.
The door was locked. I was locked out. I didn't have the keys to the place. The locks were changed. I had no way of getting in. And if you show the video properly, even the front door was boarded shut. It was extra cross with wood. I couldn't get in. The locks were changing all that. I come around to the back, and there they are standing at the back door, and I'm like, listen, let me in. And they're like, no. And I, it's like, I panicked, I was scared, and it's like, no excuse. I do a lot of mental illnesses, mental things, and I thought that they were all coming at me anyway. They had broken into my home while staying there, and the tenants that stayed there, I told Mr. McLaughlin, he's like, so what you want me to do? And I was afraid, honestly. But I was afraid that I was afraid that I would react in a way that I wasn't supposed to. I didn't know what to do, honestly. I didn't. Truthfully, I didn't know what to do. And not thinking properly and thinking that I would be smarter than them, accepting it and still coming to report against them for what they've done. That's what I thought. I've been truly, at the time, everything was happening. I was panicking and didn't want to go through it. Didn't want to go on the streets. Didn't know what's happening. And they offered money, and I said, okay. I thought I was being smart. I apologize. I didn't know what I was doing. I was very scared. I was trying to be able to come here and tell what they were doing to me. That was wrong. Because I was already locked out. The locks were already changed. I thought I was smart. I did. I apologize.
Mr. Daniels, what do you want me to do now that it's been determined, well, you've admitted that you've lied?
This is one of the most brutal courtroom moments in the entire hearing because Judge Simpson is no longer debating facts, he's confronting the damage caused to the judicial process itself. The judge is essentially saying, you admitted lying. Now what exactly do you expect the court to do with that? And Daniel still keeps trying to return to the lock change argument. But the judge's focus has already shifted. Earlier, the lockout allegation carried enormous legal weight. Now, the credibility collapse is overshadowing almost everything else. What makes this especially damaging is the ripple effect the judge starts describing. Because of Daniel's testimony, the court issued orders to show cause. The landlord had to respond formally. Legal services became involved. Community mental health paid housing costs. Court resources were mobilized. From the judge's perspective, the alleged lie didn't just affect one dispute, it activated an entire legal process under false pretenses. That's why the tone becomes much harsher here. Judges are protective of courtroom integrity because the system depends on truthful sworn testimony. Once that trust breaks, the entire structure of the case starts unraveling rapidly.
I was already, as I stated, the locks had already been changed. I was locked out. I want to be treated fairly, done right, but I conducted myself like they did.
Well, that's interesting. You want to be treated fairly because,
I treated myself like I did.
well, quite frankly, this isn't about you because you came here on the date the hearing was set. Mr. McLaughlin was not here. You told me they had locked you out,
Yes.
that you could not get back in your
Yes,
premises
yes,
and all of that, right?
yes,
But basically, he had resorted to self-help.
yes.
What that led the court to do was to then set, but now I understand why Mr. McLaughlin wasn't here because you had surrendered the apartment.
No, the doors were already locked. The locks were already changed. The locks were already changed.
So then I show cause Mr. McLaughlin to come in. He files an answer, he files a response.
Yeah.
We are back here. You go and get legal services.
Yes,
Mr. Henry appears.
yes,
And at that hearing, you continued to maintain that you were locked out.
yes. Yes.
And specifically told me that you didn't take the $400.
I lied.
I know. We get that you lied. But that you didn't take the $400, that they locked you out, that then there wasn't this period in time afterwards.
Yes.
You got community mental health because of that to put you up.
Yes.
So other monies got paid on your behalf.
Yes. They did change the locks on the door, Your Honor. I couldn't get in. The locks were changed. I couldn't get in.
Tell me why I should believe you.
Truly, Your Honor. Not telling the truth the first time it came here, you shouldn't.
I shouldn't believe anything
understand.
you are telling me.
This may be the most emotionally raw statement Daniels makes in the entire hearing. He's basically admitting to the judge's face that his own credibility has collapsed. And honestly, that admission is shocking because litigants usually spend hearings defending themselves aggressively. Instead, Daniels acknowledges outright that the court has reason not to trust him. But even while admitting that, he continues trying to preserve one core point, that the locks had already been changed before the money exchange happened. That's the detail he refuses to abandon. The problem is that the judge no longer believes the timeline. Once a witness changes stories repeatedly under oath, even truthful statements start sounding unreliable. That's one of the harshest realities of litigation. Credibility is cumulative. It's built slowly and destroyed quickly. Also, pay attention to Judge Simpson's patience here. Despite obvious frustration, he still allows Daniels to keep explaining himself. The judge repeatedly gives opportunities to clarify, expand, and speak fully. But each new explanation seems to deepen the inconsistencies instead of resolving them. Question for viewers: do you think Daniels is intentionally manipulating the story here, or do you think fear and panic genuinely caused him to make catastrophic decisions in court?
I do not believe.
I understand, but I couldn't go on after sit back praying and think about it. And you've been honest with me, you've been fair with me all the time, and I couldn't
What I do.
tell you no lies. And I had to come tell you today and let you know that. I was just afraid, Your Honor. I was
Afraid of what?
I don't know, everything. I was locked out and the locks have changed already when they gave me the money. They're all changed. I'm locked out. And I thought I was based, I don't know. I'm supposed to have a stupid. Apologize. If you get, I won't say anything else. No, that might say what else can I say? But I was being honest, now I am. I like it.
You know something? Not only did you lie to me, you recall at the last hearing, I had my bailiff put Mr. McLaughlin under oath, and we put you under oath.
Yes, sir. Yes, sir.
Mr. McLaughlin maintained the same story that he basically had put in his written communication and what he had said. He didn't have everything with him. He said he had a video and wanted to make sure that he could bring it next
Mr.
week.
McLaughlin have not been honest.
Oh.
Listen, why every time I called other people I was trying to move out of Mr. McLaughlin's place because I didn't like it there.
You surrendered possession. You surrendered possession of the premises.
No, sir.
Yes, you did.
No, sir.
Yes, you did. That's why you took the $400.
Your Honor, as I stated, the locks already changed before they gave me that. The locks already changed.
I don't believe you.
I know you would. I know you would. That's why I have to tell you the truth. The locks are already changed.
You know something? Here's no. Be quiet.
Pardon?
Be quiet. You lied to this court when you came here, caused me to file an order to show cause, got Mr. McLaughlin in. Mr. McLaughlin had to file an answer to it, find all of that information, do all of that. You go to legal services, they in good faith, Mr. Henry decides to represent you because you're saying that you've been locked out of the premises. We get here.
The courtroom dynamic has now fully flipped. Earlier, Daniels was the sympathetic tenant allegedly thrown out illegally. Now Judge Simpson is openly reprimanding him for misleading the court under oath. And notice how detailed the judge's breakdown becomes. He walks through every consequence triggered by Daniels' statements: the show cause order, the landlord's filings, legal services involvement, community mental health assistance, sworn testimony, and repeated assertions that he never took the $400. The judge is building a record explaining exactly why the court considers this misconduct serious. What also makes this moment intense is that Daniels keeps interrupting to insist the locks had already been changed, but Judge Simpson no longer trusts the underlying narrative at all. In the judge's mind, the consistent evidence now points toward voluntary surrender, followed by later regret and inconsistent testimony. Whether viewers agree or not, that's clearly where the court is landing. And once the judge reaches that conclusion, the remaining discussion becomes less about determining facts and more about finalizing findings. The emotional sympathy that dominated the first half of the hearing has almost completely evaporated.
For the second time that you've been here, Mr. McLaughlin was only here the one time, but we all get here, put you under oath, you give me your story, the story you give me, you lied. Now, in that same time, you are also lying to community mental health, who is paying to put you up as though you had been locked out. You were not locked out.
Locked out.
No,
Honestly, Your Honor, when he gave me, if to show the video, I go up the stairs. I'm beating on the door to get in. And I said to the gentleman, now they give me $400. The locks are already changed.
If that were the truth,
yeah,
then why wouldn't you have told me that you got the $400?
I'm just saying that I took it, because I had no place to go.
Why would you?
I apologize. I have no excuse. I have no excuse.
Your story
I was
just keeps changing. Your story keeps changing.
I was hungry when I was here, and I had medication, stuff that I didn't have, and I had no place to go. I had no family friends. That's what I was saying. I had no place to go. As he shows the video, I come to the door's already locked. The locks already changed. They've already changed the locks. The locks are already changed. And that gentleman come down and give me $400. The locks are already changed on the door. I couldn't get in.
Go ahead, you tell me everything you want to tell me.
That's all.
Because I don't want you to ever say I didn't give you a chance to tell me.
I told you everything. The locks were already changed on the door. When it came down, it gave me the $400, sir.
And I don't believe
And
it.
I took it.
At this point, Judge Simpson has heard enough. Daniels keeps returning to the same explanation about the locks already being changed before the money exchange, but the court is no longer persuaded. In fact, the repeated interruptions are now actively hurting him. Judges expect litigants to answer directly, stop speaking when instructed, and avoid arguing continuously once findings are being explained. Daniel's inability to stop interjecting is making the situation worse in real time, and look at the judge's reasoning here. He believes the most logical explanation is that Daniels voluntarily surrendered possession, accepted the money, later regretted the decision, and then pursued a lockout narrative that evolved over time. From the judge's perspective, the texts, the additional payments, the agreement to store belongings, and the contradictory testimony all fit that theory more cleanly than Daniel's version. Whether viewers agree or disagree emotionally, courtroom decisions often come down to which story appears internally consistent under pressure. And right now, Judge Simpson clearly believes Daniel's story has collapsed under its own contradictions. The patience that existed earlier in the hearing is basically gone.
And I don't believe you. I think that what happened here is you took the $400, voluntarily moved, which also then makes sense with what Mr. McLaughlin was saying and what he has in writing, that he agreed. You know what? I am not going to sit here and try to overtalk you, because if you keep interrupting me, you're going to be going with my bailiff. Am I clear?
Yes, sir. I'm not in an aggressive position. I'm not being that way. So I'll leave it if you want me to. Sorry.
The reason you took the $400 is because you voluntarily surrendered the premises. That's what the court's going to find, that you did that. And that the court also believes that you took the additional $400 that was later on given to you. It all makes sense. That's why Mr. McLaughlin said, I will keep, and it's in writing in a text that he would allow your property to stay there for a month. And then he gave you more money. And you're just taking money and then coming to court, causing everybody all kinds of problems.
I'm not a villain.
Oh, no, you don't even have any idea.
I took lumps. Sorry.
You keep interrupting me, so I'm done.
I didn't mean to interrupt.
I find that there was no lockout. I also find that he voluntarily surrendered the premises. Mr. Henry, I know this is embarrassing for you because you came here representing your client, believing that all of this had happened. I find you and have found you always to be an honorable attorney and always put good faith arguments. And you properly did the right thing once you determined your client was an absolute liar. And that is, you filed your motion to withdraw.
This is the decisive ruling moment. Judge Simpson officially rejects the illegal lockout claim and finds that Daniels voluntarily surrendered the premises. That single determination completely changes the legal outcome of the case. Earlier, the landlord appeared exposed to potentially thousands of dollars in statutory penalties, attorney fees, and damages. Now all of that collapses because the court no longer believes the underlying lockout allegation. But the judge doesn't stop there. He also publicly acknowledges legal services attorney Mr. Henry, specifically praising him for acting honorably once he realized his client had not been truthful. That's an important professional moment in the courtroom because attorneys have ethical obligations to the court once credibility issues emerge. Judge Simpson is making clear that he believes counsel handled the situation properly after discovering the contradictions. What's especially striking is how dramatically the emotional balance flipped over the course of this hearing. The landlord went from potentially facing severe penalties to winning dismissal. Daniels went from sympathetic victim to someone the judge openly labels dishonest under oath. Few courtroom hearings reverse direction this hard.
So prior to entering what I'm entering, I'm going to grant your motion to withdraw. find that it's surrendered. This case is dismissed, but you are entitled to possession of the premises. Oh, yeah. It's yours. He gave it up. You want to know what? You keep it up. What did I tell you? You think I'm kidding? Do you think I'm kidding? Then I'd suggest what you do is you turn around and you walk out and don't say another word to me, because if you say another word to me, you're going to go with Officer Mahalik. Have a great day. Okay, court's going to stand in recess.
And that is how this courtroom saga finally ends, with Judge Simpson shutting the entire situation down after completely losing patience with the interruptions. The final ruling is crystal clear. The court found no illegal lockout, determined that Daniels voluntarily surrendered possession, dismissed the case, and allowed counsel to withdraw after the credibility collapse. But beyond the legal outcome, this hearing became a masterclass in how credibility can completely determine the direction of a case. Early on, Daniels appeared highly sympathetic. The court was discussing statutory penalties, emergency housing, attorney fees, and serious consequences for the landlord. But once contradictory testimony and admitted dishonesty entered the picture, the entire case inverted. Judge Simpson ultimately concluded that the timeline, payments, and surrounding conduct aligned more closely with voluntary surrender than unlawful eviction. The biggest takeaway here is simple. Once a judge believes a witness has lied under oath, recovering credibility becomes almost impossible. Courts can forgive confusion. They can forgive emotion. They can even forgive bad decisions. But knowingly misleading the court is another level entirely. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.